Well, in the past, we've been looking back at some of the top ag law and tax developments from 2023, covering everything from Prop 12 to foreign ownership of ag land. Well, today, we have made our way down to number one. That is the list Roger McEowen has been putting together with the Washburn School of Law. This is your number one, of course, lesson that we need to follow. So tell us about this.
Well, this, as many people probably could predict easily, is the U.S. Supreme Court's ruling last May 25, the Sackett versus EPA decision involving the definition of a wetland and the jurisdiction that the Corps of Engineers and the EPA have under the Clean Water Act. It was a big case because it resulted in a unanimous ruling by the court, at least they were unanimous on this point, that the substantial nexus test is not the way we determine whether a wet area is subject to federal government control.
And the big takeaways for this, Roger, I mean, this is something, boy, that has played out over years, and everybody was watching this. Big impact on ranchers.
Oh, huge. When the Clean Water Act amendments were made in 1972, we had a definition of a wetland put in that was kind of vague, and the courts had to fill that in over the years. And this has gone back and forth in the courts. It's gone back and forth depending on what administration is controlled in terms of what the definition is. And the big issue for farmers is whether ephemeral streams that cross their property, whether ditches, other types of wet areas that are sometimes wet is subject or could lead to subject to jurisdiction by the federal government. And it is a tremendously huge issue. And the court, in essence, said that the current administration's rule was inappropriate because it used the substantial nexus test. So they kicked us back to essentially the Trump rule, and even earlier than that, to, I think, what more closely aligns with original congressional intent. But don't expect this issue to go away. The EPA and Corps did modify their rule after the court decision came down because they had come out in front of the court and issued a new rule, and the court basically said that's not right. And so the agencies wrote a new rule, and that's already been challenged because the argument is it doesn't comply with the Supreme Court's opinion. So this will continue to be a big issue in 2024, and it is a huge issue for rural landowners, for farmers and ranchers nationwide.
What do you think is going to happen as we move forward? I mean, any predictions here on how this is all going to play out?
Now, a lot of this is tied up in politics in terms of the regulatory agency's definition. The emphasis tends to change with the administration that's in control. But I do think we have a much clearer definition from the U.S. Supreme Court than we had from the last time that they dealt with this in an opinion almost 20 years ago. So from that standpoint, I think we're on a better ground going forward. But that doesn't mean the issue is going to go away. I still think it's going to be in the courts and an issue for Congress to continue to deal with in terms of trying to come to grips with what the U.S. Supreme Court has said.
Well, Roger, thank you, as always, for breaking this all down for us. Of course, going through this entire list, taking us all the way to number one today. So I appreciate that. Of course, have a safe trip wherever you are. I know you're in Colorado, and we'll see you back here on RFD-TV soon. Roger McEowen with the Washburn School of Law. Thank you.